Hello everyone, I'm joined today with Jamie from Surrey County Council, and we're going to be talking to you as part of our bite-sized videos today about the tribunals. So this video is going to be very much about the context of what a tribunal is and also the process that parents go through. So first of all, Jamie, did you want to introduce yourself?
So hi everyone, my name is Jamie Conran. I work for Surrey County Council as the service manager for policy, practice and performance. And what that includes is I manage or have overall responsibility for the tribunal team.
Brilliant, thank you so much. So parents have sent in lots of questions related to the tribunals that you're kindly going to answer for us today. So we'll just kick off, shall we? And I'll start with the first question. So it's a pretty straightforward question, really. So what is the Send Tribunal?
Yeah, so it can be a straightforward question, or it can be, it depends how you
I guess.
So there might be some other, so we refer to it most commonly as the Send Tribunal. Other times it might be referred to as the first tier tribunal, so for special educational needs and disability. And it's part of the Health, Education and Social Care Chamber, which is one of 7 chambers of the first tier tribunal, which settles legal disputes and is structured around particular areas of law. So that sounds really complicated, but actually in simple terms, the first tier tribunal, or the Send Tribunal, hears appeals against local authority decisions regarding special educational needs and disabilities. A key thing about it is it's independent, and it places itself in the local authority's shoes, and it reevaluates all of the information, all of the available information that it needs to make a decision. So it's all of that part sounds complicated, but that's what the Send Tribunal essentially does.
Brilliant, thank you. And what are the reasons a family might appeal?
So there's potentially a number of reasons why families would appeal, but the decisions that they can actually appeal, there's a few of them. So the first one is where a local authority does not agree to carry out a statutory education, health and care, so an EHC needs assessment. The next one that sometimes follows is the local authority does not agree to issue an EHC plan after it's completed a statutory EHC needs assessment. You can appeal the contents of an EHC plan. So that could be the description of a child or young person's special educational needs. So that would be section B. The special educational provision that's specified in the plan. So that would be section F. And the school or other educational setting or institution that's named in the plan, or the type of school that's been named. And so that's section I. And then there's any combination of those. So you could do section B and F, or you could do section F and I. So special educational provision and the setting. There's some others that you can appeal. So a decision by the local authority not to secure a reassessment of your child's needs. There's a decision not to secure the amendment or replacement of an EHC plan following a review or a reassessment. So that's like, if the local authority didn't agree to make any amendments post annual review. And then there's the decision to cease to maintain an EHC plan for a child or young person. So there's quite a few reasons. And just as an additional note, sections regarding health, so sections C and G, and then social care, which are sections D and H, you've got H1 and H2. They can also be appealed as part of what's called an extended appeal. But the difference is the tribunal can only make non-binding recommendations about these areas, and there must be an education element to the appeal.
Brilliant, thank you. There's quite a lot there, isn't there? It's yeah. That's brilliant. And something we get asked quite a lot is why can't you appeal an EHCP when it's in the draft stage?
Yeah, so that's an interesting one. There are specific regulations. So you've got specific sections of the legal framework, and one of those they're called the send regs or send regulations. There's specific regulations in those 13 and 14 that ensure that when a draft EHC plan is issued, parents and carers or young people are able to make representations, so to give feedback regarding its contents and, if needed, to request a particular school. So to allow for that, appeal rights only come into force once a final EHC plan has been issued, and that's section 51(2)(c) of the Children and Families Act. So it's a good question, but there's specific regulations around that in line with the legal framework.
Brilliant, thank you. And so where can parents find out more about the appeal process? So things like the forms to complete and any services that can help support them with lodging an appeal.
Yeah, so when the local authority makes a decision that can be appealed to the send tribunal, it will send a notice of this decision to you, parents and carers, or directly to a young person. Within this notice, there is information that must be included, and that relates to your right of appeal to that decision, information relating to mediation, and then some availability of disagreement resolution services, but also information around any information and advice relating to special educational needs children and young people, where you can get that from. So in Surrey, we'll send a letter containing a decision, but also all of those things, so your right of appeal. And within that letter, we link to Send Advice Surrey, which is our statutory information, advice and support service, so our Send service. And they can offer information, advice and support relating to the tribunal process. You can also go on the government's website directly. There's a tribunal website. If you type in first tier tribunal government on any search engine, it will come up. And you could also look at the IPSI website. Lots of resources on there that take you through. So our initial letter covers the sort of basics, but in relating it to Surrey, it's Send Advice Surrey provides some support, but you can also go to have a look at IPSI.
Brilliant, thank you so much. And what are the costs associated with appealing?
So there are no specific costs in terms of the Send Tribunal doesn't charge a fee. So you can submit an appeal. There's no pay £10 to submit or lodge an appeal. There's none of that. It's a free service or free process, sorry, for parents and carers or the young person's appealing. Some families do choose to employ legal representation, which will come at a cost, but it's not a requirement. And there are services, the ones that I've just mentioned. So you've got Send Advice Surrey that provides support around the tribunal process, and IPSI as well. So they've got like a helpline and things. So in terms of the actual tribunal, it's free, unless you wanted to maybe employ some legal representation, which would obviously come at a cost. But there are other services that don't charge to provide advice and guidance through the appeals process.
Brilliant, thank you. And in terms of the time it takes, so is there a timeline so families know what should happen once they've lodged an appeal up until the hearing date?
Yeah, so if you think about the start, so you've submitted your appeal, you've submitted the paperwork. The Send Tribunal aims to reply within about 10 working days of when it registers. Right now, and historically, we know it can take longer when the Send Tribunal receives a lot of appeals at the same time. An example of that is around key stage transfer. So maybe a child moving from year 6 to year 7, they receive a lot of appeals nationally. Sometimes it can be a bit slower. In terms of the start to finish of the appeals process, the Send Tribunal typically aims to have a hearing date approximately 12 weeks from the date your appeal was registered. However, with what I was just saying, when it's really busy, we know that the Send Tribunal can prioritise cases. So sometimes they expedite or they bring forward certain types of hearings. And then some appeals get adjourned, so they get pushed back. With all appeals, if you look for the tribunal's registration letter, that informs you of the hearing date or the date the appeal will be considered, and other important deadlines, such as when you and the local authority have to submit final evidence by. So I would look at that letter, and it will give you all of the relevant dates.
Brilliant, thank you so much. And so this is something else we hear from families quite a lot. So who is responsible for a child or young person's provision whilst the family is within the appeal process?
Yeah, so there can be different answers to this. So I'll go with the sort of more common ones. So if there is an appeal against a local authority's decision not to carry out an EHC needs assessment, or if it's a refusal to issue an EHC plan, then provision will continue as normal through the educational setting. So that might be through SEN support. And that's because there's no EHC plan in place, because that's what the local authority has either not agreed to carry out an EHC needs assessment, or it hasn't agreed to issue a plan. There might be some different cases, different scenarios, and I'm sort of thinking maybe if you were electively home educating, then actually nothing really would change if you've got an appeal until that appeal is concluded. But I would say if you're in any doubt, you can always contact Send Voice Surrey for information, advice and support around who is ultimately responsible. And then if there is an existing EHC plan in place, and you might be appealing the content, so you might be appealing section F of the plan, the original, the version of the EHC plan that is already in place, that will still apply until the appeal is concluded. So that means that the contents of that plan still need to be delivered, and more typically it's via the school that's already been named in the plan, but the local authority maintains overall responsibility. So there will be some nuances to that, but generally that's who's responsible. So it should be, without an EHC plan, generally the school is going to carry on, they're still responsible for delivering. And then once there is an EHC plan in place, local authority still maintains overall responsibility. Brilliant,
thank you. So we're going to move on a little bit and talk about the appeal process. So what happens once you've lodged the, so if a family's lodged an appeal, what would happen after that?
Yeah, so as I mentioned earlier, the Send Tribunal processes it and registers it, and it sends that registration letter to both whoever's appealing, so more commonly parents and carers, and the local authority. And just again, that registration letter contains all of the detail in terms of the key deadlines and the key dates, such as the hearing date, or the date the tribunal will consider the appeal. And then what we do in Surrey is you've got the local authorities tribunal team. They will triage that. When they receive that initial appeal paperwork, they'll triage it to determine the nature of it. So what's the appeal about? And then the tribunal team will have overall responsibility for how it's managed until it's concluded, so it's run its course. So that's what happens when both with the Send Tribunal and the local authority on immediate receipt.
Brilliant, thank you. And who can parent carers or the family, young person, contact at the local authority during the appeal process?
So the main point of contact will be the tribunal team. So we've got an email address, which is send.appeals@surreycc.gov.uk. I'm sure we can provide that link.
Absolutely.
And then once we've allocated to a tribunal officer, they'll remain your point of contact until the appeal ends. But what we advise is for parents and carers to also copy in that email address that I've just said, so the send, because then if we've got a member of staff that's on holiday or is maybe unwell, someone else will pick it up, and it means that we receive it. So that's the main point of contact throughout the appeal process.
Brilliant, thank you. And something that we hear from families is that, you know, they've lodged the appeal, but they've heard nothing from either the send or the appeals team when they lodged it quite you know, how they feel quite a long time ago. And when should they expect some communication from, you know, either the send team or the appeals team?
Yeah, so and I can completely understand that. You know, it might feel like just sort of silence. Well, what's happened here? So the local authority, when we receive the registration form, and you've got the key dates, and we've triaged and we've tried to understand the nature of the appeal, the local authority generally has 6 weeks to consider it and then put forward its grounds of response. So the local authority's grounds of response, which means basically that's how we're responding to the tribunal. So we've had a look through this. Are we going to continue to defend or not? Or are we going to take a different approach? So typically during that 6 weeks, tribunal officers use that time to understand the appeal. Sometimes they come with a lot of paperwork, and they can be quite complex, just to even understand what's being asked for, what's the current information, what does it say. So they use that time to determine the issues and then liaise with professionals, maybe local authority officers, so they might speak to the send team and they might speak to the school. So that can take time. So it's not the case that it's sort of nothing's happening, but they may not make immediate contact with the family. But what we would say is, you know, if tribunal officers have any questions or are trying to understand something a bit more, they do contact families, and vice versa. You can contact them and say, you know, what's happening here? Can you have an update? And we always try to make sure that families are updated throughout the process.
Brilliant, thank you. And another thing that we hear from families quite a lot is when they receive the response to the appeal from the local authority, and it's quite often not completed in much detail, and seems a little bit vague for the reasons to defend the appeal, and quite often for the witnesses section, for example, it says to be confirmed. So the question we've had is how is the local authority allowed to do this when it's a requirement with a deadline set by the tribunal?
Yeah, that's a really good question. Sometimes where maybe the response can feel vague or doesn't offer too much certainty in terms of what is the local authority doing with the appeal. Is it defending, or is it going to perhaps no longer oppose? Quite often the local authority is seeking additional information that will be key as to how it's going to proceed. So an example of that would be local authorities waiting for a consultation response or some specific paperwork from maybe a school or from an education psychologist or a therapist. And at the time, so in the 6 weeks that the local authority has to respond, it's not been able to pull together everything. So the response might say, you know, from an initial review of all of this paperwork, Surrey County Council intends to defend this appeal, but we're still waiting for A, B, and C. And then, you know, once we receive A, B, and C, we might take a different approach to the appeal. So it's almost 6 weeks is a long time, but sometimes it's not a long time to get all of the information that the local authority needs. So that's why I can understand how parents can use that word vague, but that's generally the reason we're waiting for further information that we've requested. Regarding responding to witnesses, this has come up with the TBC, and it's come up with the Send Tribunal itself, because from the local authority's point of view, to allocate a witness right at the start of an appeal and to name a witness, you don't generally know where you're going to end up by the time the appeal has run its course, because generally they keep changing. So the tribunal have recognised that, because TBC doesn't really help anyone. So they rolled out what's called a case review form, and that says that witnesses should be listed, but they're rolling it out at the moment. So I think this is one of those things that might change. It should improve the experience for families. So they should know generally, or the local authority, if they're bringing a witness, that we know who they are. And I think that's been recognised as one of the sort of areas to improve by the Send Tribunal, because a lot of local authorities, right at the start, when you're asked to name your witnesses, it's almost too early. So yeah, keep an eye out for those. Any sort of new appeals, you should see that case review form.
Brilliant. No, that's really interesting. Thank you. And so what happens if the local authority have not met the deadlines set by the tribunal service? And we do hear from families where this has happened. And so why is this happening, and what can a parent do, in this instance?
So yeah, so it is, from our point of view, it's a rare occurrence where the tribunal team or the local authority doesn't respond to a set deadline, and often it's because sometimes they're quite tricky to spot. So you might get several deadlines within a registration letter, and there's one that you miss. But what you can do, you could contact your tribunal officer directly and say, I haven't been cited on your response as a local authority to this deadline. But what you should also do is just notify the actual Send Tribunal. So you quote the deadline, you quote the appeal number and the deadline that's been missed. What usually happens is the Send Tribunal responds with an order to the local authority, ordering the response, but also saying, you need to explain to us as a tribunal why you have missed the deadline. And there's various things. So potentially the local authority could be barred from all, so basically they couldn't participate any longer. That's quite a punitive measure. So it would have to be a pretty extreme, the local authority has not responded to either something extremely significant, or they're just not responding at all, for that to happen. So as I would always think you can always contact the tribunal officer, say you haven't responded, what's happening, but also contact the tribunal to let them know, because they will give us an order to say, explain yourself. So then, and we have to explain ourselves, we have to say why we've missed it. So it keeps us held to account as well.
Brilliant, thank you. And this is something else that we get asked quite a lot. So who has the authority to amend and agree the working document?
Yeah, so this is a really good question. So in Surrey, tribunal officers act on instruction, so from the Send team, so they'll receive instruction from the Send team, but also in accordance with advice from therapy services, education psychologists, educational settings, because tribunal officers generally aren't speech and language therapists, so they might be aware of the amendments that are being requested to an education healthcare plan via the working document, but it's not their professional area of expertise. So what happens is the tribunal officer has overall responsibility for managing the working document, but they need to consult, they need to speak to maybe a speech and language therapist, maybe an educational setting, before agreeing changes to the working document. And that's to ensure that everyone is cited on the process. So for example, you wouldn't want a process where lots of amendments were made to an education healthcare plan, sections B and sections F, and the school weren't aware of any of it. And then you end up with a really different education healthcare plan and the school says, but we don't do this, 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 and this. And then we'll say, but we can't, you know, we can't deliver the provision that your child needs. So that's why we try and we're always trying to consult and liaise with as many people, relevant people, before agreeing changes to the working document.
Brilliant, thank you. And the last question on this process is, when a family's received the bundle for their appeal, and they notice that there's lots of documents missing, so why would that happen, and what can be done if that happens?
Yeah, sometimes the bundles are large documents, and I think where we found that we've submitted a bundle to the tribunal, and we've had feedback that, oh, that doesn't include maybe a consultation response from a school. It's sometimes where the size is so big, there'll be a technical glitch with the software. Where we found that it happens more often is when documents are password protected. So the tribunal doesn't accept them, the send tribunal doesn't accept them. So our advice is to try and, where possible, have documents, if you're submitting evidence, and certainly when the local authority submits evidence to put towards the bundle, we try and make sure they're not password protected. But the simple answer in terms of what to do next is just let your tribunal officer know. And what we will do is generally we take very quick action if we spot that, and we update the tribunal with the missing pieces in the bundle. So it's not it might feel like a common occurrence. It's not too much of a common occurrence for the tribunal team. It does happen, but I know that the send tribunal are looking at bundles as part of their development moving forward. So it might be another one of watch this space and see how it changes moving forward.
Brilliant, thank you so much. Well, that's all the questions on that, and we are going to be doing some other recordings all about tribunals, so look out for them. But thank you so much, Jamie, for answering our questions today. Really appreciate it. I found it really interesting. Thank you.
Thank you.